historic Mount Zion United Methodist Church. My name is Karen Jones. I'm the Director of Administration for the NAACP Virginia State Conference. We are excited to have you all here as we discuss and share the federal court ruling striking down the reinstated Confederate names for the schools here in Shenandoah County. Today, we are going to be joined by, and you're still from in this order, Reverend Cozy Bailey, President of the NAACP Virginia State Conference, A.D. Carter, one of our student plaintiffs, Tim Carter, mother of the student plaintiff, Brown, mother of the student plaintiff, Lee Reed, one of our fantastic attorneys, and Martha Placer, one of our attorneys with Washington Lawyers Committee for Civil Rights and Urban Affairs. We will, for all present in attendance and those who are able to be with us, we will share a recording following today's press conference. And with that, I'm pleased to introduce NAACP Virginia State Conference President, Reverend Cozy Bailey.
And thank you, Karen. Welcome to all who are gathered here today as we commemorate, celebrate, and just go crazy about this great momentous thing that has occurred. I have some prepared remarks, but I got to tell you, the true heroes behind what has occurred here, what was announced on Thursday, are standing behind me. I was talking to A.D. I said, how does it feel to be a history maker? Right. His name and others will always be connected to what has taken place here in Shenandoah County. And what took place? On Thursday last week, U.S. District Judge Michael Urbanski ruled that Shenandoah County must remove the name of 3 Confederate generals from its schools. This ruling delivers a clear and powerful message that every student in Virginia deserves the full protection of our Constitution. This ruling affirms what the Virginia NAACP has long stood for, that the First Amendment, the 14th Amendment, and the Equal Educational Opportunity Act exist to protect every child, regardless of race, background, or belief. And when any entity or person works to subvert these laws and principles, the law must answer. The importance of this ruling is multi-layered. The immediate effect is on you, the people of Shenandoah County, who joined with the Virginia State Conference to bring this matter to the courts. You are vindicated, and you ought to give yourselves a round of applause. Now, for some, this victory is bittersweet, because the wheels of justice turn so slowly, they were forced to endure the dignity of daily entering a building that had been renamed to honor men who had fought to dishonor their ancestors. But this ruling is a signal to all that false narratives used to cloak and hide underlying racism will not stand up to the application of law of the land. For decades, the practice of honoring Confederate leaders in Virginia schools has been steeped in a history of racial discrimination. The board's 2024 renaming decision is impossible to explain except through the lens of race. The release of this ruling on the anniversary of the signing of the Voting Rights Act of 1965 is both ironic and bittersweet, because as we fight to claw back the critical voting rights that have been almost totally eviscerated, we celebrate at the same time a victory of human rights, civil rights, and the dignity of this momentous decision. Since the inception of the NAACP in 1909, we have tirelessly fought for true equity as citizens guaranteed in the 14th Amendment. And our work is rooted in racial equity, civic engagement, and the supportive policies and institutions for all marginalized people. We will continue to stand in the days ahead with the students, the families, and educators of this community who have the courage to bring this fight forward. And we will stay with them in the face of any potential challenges or appeals to this ruling. Their persistence produced a ruling that strengthens constitutional protections for school children across the Commonwealth. And by the way, there's now a functional and vibrant NAACP branch here in Shenandoah County. The Virginia NAACP will continue to hold every school district in the Commonwealth accountable to the full promise of equal education. Justice in the classroom is justice for our future. Injustice anywhere is a threat to justice everywhere. And we will stand in that gap whenever and wherever needed. God bless you all, and thank you very much.
Good afternoon.
Good afternoon.
Church is tough. I'd like to start off with saying that when I heard the verdict, I was in Maryland hanging out with my buddy, but my mom texted it to me, and I just started losing my mind. Right, we were playing this board game that he used to the board game. So my mom texted me, I started losing. I'm jumping around this dude's house. I mean, I'm losing. But he's like, what's going on? What's going on? And so I told him, I said, hey, we just won. And so, of course, he's asking, what'd you win? And so, so I had to tell him, I said, hey, we just beat discrimination. What? So, yes, initially, I want to start off the speech talking about Oliver Brown, because we know Oliver Brown, Robert's Board of Education, he really started this, right? We're continuing this fight. That's really what this is, and I really appreciate everything these folks behind me have done for me and for this community. And I just want to say that I hope this sets a precedent that moving forward in our schools, we can remember things like this and days like Thursday. That moving forward, we can remember that this is no place for discrimination. This is a place where we can all focus on education and enrichment and moving forward.
Hello, my name is Kim Carter. I am the mom of AD. He's very passionate, as you can tell. I'll take a little credit for that. I am a history teacher, so he gets a little of that honestly. So I dug in a little bit to the history. We moved to Shenandoah County before he was born. So I did look in a little bit to the history of the school. So when Stonewall Jackson High School opened in 1959, my son and anyone who looked like him would not have been allowed to attend there. And because of the color of the skin. At that time, Shenandoah County chose to ignore the mandate of Brown versus Board of Education and delay that promise of equal access to education. For years, that school carried a name associated with a period when students of color were excluded from any opportunity afforded to others. While that school eventually did desegregate, it carried that legacy that has never been forgotten. The decision to restore that name in 2024 felt like a huge step backwards. For many, it was more than a name change. It was a reminder of history, of exclusion and discrimination. When last week's court ruling came down, the hope that could be restored for Shenandoah County was just a little glimmer in, the hearts and minds of those behind me, and hopefully more in the county. I'm hopeful that we can move behind that hurtful chapter and focus on building a future that brings people together, and our schools can be a place where everyone feels welcome and respected and valued in our county. Thank you.
But I just want to say that, we were very pleased with the decision of course. I feel like it's, a positive step in the right direction. Feel like we still have a long way to go, but this is a positive step in the right direction for this county. I was born and raised here, so I'm happy that decision was made. I also appreciated the judge's thoroughness in the case. I really appreciated him taking his time in making his decision. And most of all, I really appreciate the legal team that took such great care of our kids. They showed so much kindness and compassion for them, and they really kind of felt like family through this whole process. So I just want to say thank you.
Good afternoon, everyone. I'm Lee. I'm one of the attorneys that represented the plaintiffs in this case. And good afternoon, everyone. I'm Marjorie Cleaner. I'm also part of the plaintiffs team. As everyone described before us, this case has always been about protecting students from an environment that celebrates Confederate names and symbols that are known in the community to represent pro-segregationists and anti-Black principles. The school board knew this when they took the names off of the schools in 2020. In September, we argued summary judgment for the First Amendment, and we won where the court found that the Confederate names violated students' First Amendment rights to free speech. And now, after a week-long trial in December, the court has just found that Confederate names violated Black students' right to attend schools free from discrimination. We're very proud of our client's advocacy, and we're grateful for the court decision. It signals that these critical civil rights protections remain enforceable. We're hopeful that the school board will abide by this decision as soon as possible. School starts this week, and they still have time to remove the Confederate names from the schools before school starts. But we want to be clear that if they don't do that, it will cost Shenandoah County. So, to start, our clients have never saw money in this case. They only sought for the names to be removed so that students will feel welcome and safe in their school environment. Plaintiffs also made every effort to resolve the case without costly litigation. Before involving counsel, they sent multiple letters, they went to school board meetings, they advocated for themselves in every way possible to stop the school board from changing the names, from restoring the Confederate name system. And once they engaged counsel, we sent a letter saying, hey, we believe it will be illegal for you to restore these names for these reasons. Please don't do it. But they didn't keep that letter, so we proceeded to litigation. Over the course of litigation, we have reached out to the school board through counsel several times to ask them to settle, to offer them, if you please take the names off, we'll take no fees. We just want these students to feel safe and welcome in their school. And the school board did not take us off of any of those offers. The school board chose to pursue vigorous litigation, and so we had to vigorously defend our claims. That resulted in more than 10,000 attorney hours over the course of 2 years. And now that we've got a decision, Shenandoah County is responsible for paying those fees. We want to draw the line now. We don't want to draw this out any further. We urge the school board to remove the names now. We're still open to negotiate, to minimize those fees as much as possible, to minimize the cost to the county as much as possible. So again, no more students have to experience the harms of the discriminatory names. However, counsel for the school board has represented that they will pursue appeals. And if they do, it's our responsibility to continue to vigorously defend our clients and defend the court's decision. If the school board chooses not to remove the Confederate names now, it's gambling with millions of dollars of taxpayers. Marcia and I will now take any legal questions that you have. So they have communicated to the press that the plan has been to appeal to their federal law now. They haven't talked to me personally. They have not signaled back specifically to us personally, but we have a conversation with school board council to determine next.
Right, one thing is that, I believe the order is a specific timeline for these new names, or not. I know you said this week, I think I'll have that from you, matter of time to expect something to do, to expect what they were, or how could you expect the law?
Right, so in argument of the order, the court is stating to remove those names. The court order does not set an actual deadline, and that's what we would be asking, urge that, Shenandoah County School Board does in fact choose to do that. So it's not currently in the order, however, when we are successful under certain civil rights statutes, you are entitled to terms.
Approximately how much?
That's a good question. The most we could say is several million.
The average attorney cost nowadays is around $400 now. And I believe they said they invested 10,000 hours so far. So you do the math. Make sure that the citizens of Shenandoah County are aware.
With an official appeal, would that supersede removal ordered by the judge until that appeal is determined or not?
The school board would have to petition the court to stay the decision, which means to pause any action, any appeal. And our real opinion is sort of that the school board will possibly go on.
If the stay is pursued, is it at the district level or the circuit level or both? And is the standard irreparable harm and likelihood of next?
If they pursue an appeal, we'll go to the school board.
But I mean, the petition for stay, would that be Judge Urbanski or would that be the
It should go to Judge Urbanski, but one notice Judge Urbanski is close to retirement, so we're not sure how that will impact which judge.
Thank you.
Final comment from President Urbanski.
I want you as Virginians to remember the names of Carter and Brown. when you understand what happened here today. Let's give them another hand. As Virginians, we are really cognizant of the names of Spotswood Robinson, Thurgood Marshall. As you remember today the name of Reed and Plater and others who also will go down in history.